His counsel, Ms. Kelly and Mr. Johnson, are present on behalf of the state. I have a motion to reduce bond in front of me. Ms. Kelly, anything else the prosecution is hoping to accomplish today?
Nothing to report, Judge.
Mr. Kelly?
Thank you, Your Honor. Your Honor, as the court knows, this matter is also set for status, and so I do anticipate advising the court briefly of sort of what the parties have discussed regarding timing, other than the timing issue.
Excuse me just a moment. If you are on the WebEx, you need to make sure you remain muted the entire time. If you don't remain muted, you may be removed from the WebEx room. My apologies, Mr. Billy.
Not at all, thank you. Your Honor, other than the timing issue and the bond issue, I do not believe that there's anything else that I had planned on addressing today.
Okay.
Thank you.
Mr. Beller, as it is Mr. Morphew's motion, do you have any witnesses you want to present with regard to the bond issue?
We do not have witnesses, Your Honor. I will simply be making an oral argument. I would note for the court, however, that Mr. and Mrs. Morphew's two daughters are also present in court.
My apologies, yes, I did notice that. All right, and I will note that several of the victims are also present on the line.
Understood.
Ms. Kelly, do you have any witnesses you all wish to present with regard to the bond issue?
No witnesses, just for one, Judge.
Okay, Mr. Beller, whenever you're ready.
Thank you, Your Honor. Your Honor, I have already set forth the statutory factors and the constitutional factors, of course, in my written motion, and I am not going to go through and recite those. But in making an argument, I believe that there's several things that the court should take into consideration. Your Honor, I very much believe, and Ms. Barry also very much believes, that we have an innocent client that we are representing. I say that not just constitutionally, Your Honor, and of course the court knows that there is a presumption of innocence, but also we have factual innocence. And while I understand that this is not a proof evident presumption grade hearing, I do believe that it is important for the court to at least take into consideration the perspective of the defense coming in to representing Mr. Morphew and in arguing this motion. Your Honor, as the court knows, several years ago, the evidence was heard in a proof evident presumption grade hearing, and ultimately Mr. Morphew was determined to be eligible for bond in a time and in an era where, candidly, that is relatively unheard of. The law, of course, has changed since then, but Mr. Morphew, through both grand jury, is not entitled to proof evident presumption grade, and ultimately statutorily for the time period in which the offense is alleged to have committed is not entitled to proof evident presumption grade. But that track record, I believe, is telling and is something that the court should and can change or take into account. And I admit that the evidence has changed to the slightest degree, of course, thankfully, with the discovery of Ms. Morphew's body, but importantly, the substantive evidence and the problem that the government has had in finding the proper person responsible for this offense, Your Honor. The evidence itself has not changed, although the theory of the government has, and that has been ever evolving. Your Honor, the evidence of Mr. Morphew's innocence is substantial, and I think through the coming months the court will see that when the time is ultimately proper. But in deciding whether or not to reduce Mr. Morphew's bond from $3 million to what the defense is asking for, which is $500,000, the court should take into consideration and can take into consideration Mr. Morphew's past conduct. We know, Your Honor, that Mr. Morphew was released on a $500,000 bond. And throughout the litigation of Mr. Morphew's case, Ms. Morphew's unfortunate death, Mr. Morphew did exactly what bond is supposed to do, which is that Mr. Morphew appeared for every single court appearance. He followed every single requirement of the court, and at no time had any problems complying with the orders of the court. And there is nothing about the evidence and there's nothing about the charge that has ultimately changed that. Your Honor, Mr. Morphew, while living in Arizona at the time of this second arrest, it doesn't change the fact that he has substantial ties to the community. Those ties, in many ways, are spelled out in the motion, and I'm not going to go through and recite those. But Mr. Morphew obviously maintains an incredibly close relationship with both of his daughters, statutory and even non-statutory victims in all sense of the word. That is compelling for him to continue to comply with orders of this court and ultimately see this case through to its legal conclusion. His mother, of course, he remains very, very close with. And then Mr. Morphew has countless friends that are also in the area. Mr. Morphew has established, as stated in the motion, a place to be able to stay here in Colorado, should the court determine that that is most appropriate, or if the court were to permit him to return home to Arizona. He also has a home in Arizona with substantial ties to Arizona, noting, of course, that he did return to Colorado when he was supposed to in other proceedings. Your Honor, Mr. Morphew has had counsel on this matter for 5 years since the loss of his wife. Counsel has maintained and remained in contact with the prosecution during that entire period of time. And so even when there were no active judicial proceedings, counsel for Mr. Morphew stayed in contact with the people such that Mr. Morphew's whereabouts were known at all times. Mr. Morphew certainly had the legal right to be able to leave the country if he wanted to. He had the legal right to maintain anonymity if he wanted to and if he chose, but Mr. Morphew did not do that. That is important because even when Mr. Morphew had absolutely zero legal ties to this jurisdiction, we remained in contact with the prosecution that entire period of time. As the court knows, when an individual is unable to post a bond, that is an indication for the court that the bond is set too high. Bond, as the court knows, and I will not waste your time reciting law to you that the court already knows, is done for the purpose not in determining guilt or innocence, but is done for the purpose of making sure that somebody comes to court, answers to court, is accountable through due process. And the fact that Mr. Morphew's bond is at $3 million and has been since June, and Mr. Morphew has not been able to bond out, is an indication that the bond is set too high. And ultimately, in this case, Your Honor, there is little to no justification in my mind as to if the question of if $500,000 was enough to ensure Mr. Morphew's compliance, and did, in fact, ensure his compliance without single failure, why then is $3 million the appropriate amount to be set now? Your Honor, candidly, Mr. Morphew does not have the same financial assets that he did several years ago. Certainly not in 2020 or even in 2023. $500,000 was much more accessible to him several years ago, and ultimately he was able to pay that. Mr. Morphew is now in a much different financial situation than what he was before. And so $500,000, which is the request of the defense, while high enough last time to ensure his compliance, I would argue now is even that much higher for him because it's going to be that much more difficult for him to be able to come up with those sorts of funds. And candidly, there's going to be a lot more people who are assisting Mr. Morphew ultimately with their own accountability to both the funds as well as to this court. And so under the circumstances, Your Honor, and for all of the statutory reasons cited in the motion, as well as the oral motion made today, I would ask the court to consider reducing his bond from $3 million cash only to $500,000 cash only, with any other requirements that the court may require, ultimately requesting the court allow Mr. Morphew to reside in Arizona, but even if the court determines that that is of too high a risk to the court, certainly Mr. Morphew is more than willing and happy to remain in the jurisdiction and in Colorado should the court consider a reduced bond. Thank you.
I have some questions, Mr. Bowers.
Yes, please.
First of all, and you don't need to use proper names, but
Understood.
you said that Mr. Morphew has substantial ties to this community. From my perspective, this community is essentially the 12th Judicial District.
Absolutely.
Does he have ties to this Judicial District?
Your Honor, to be fair, the answer is no. We'd be talking about neighboring jurisdictions, directly neighboring jurisdictions. As the court knows, this matter is currently being heard and held in Alamosa, although arguably Saguache County would be the proper jurisdiction. That's something that we can discuss later. Ultimately, I would say to the court that the proper jurisdiction is Saguache. But even then, I cannot and will not represent to the court that Mr. Morphew in that very, I think, rural jurisdiction has substantial ties to the 12th necessarily, but rather to neighboring jurisdictions.
And you stated in your motion that Mr. Morphew, when not in custody, is employed. Is he self-employed or does he work for him?
Your Honor, he was self-employed. We do have contacts within not this jurisdiction, but neighboring jurisdictions, many of whom have indicated that they would be willing to employ Mr. Morphew, but I will not represent to the court that that is ultimately lined up at this point for very obvious reasons. But we have no doubt that employment will certainly be possible upon his release.
If you know, how long did Mr. Morphew remain in Colorado following the dismissal of his previous case?
Not long, Your Honor. Mr. Morphew, and I do believe that this has already been reported, and I'm happy to answer. After the dismissal, Mr. Morphew stayed in Colorado for a very brief period of time. He then relocated to Indiana and was very close with his mother in Indiana. Ultimately, he went to Arizona with other family members and remained in Arizona after that time with other family members.
And since that time, other than Colorado, Arizona, and Indiana, has he been present in any other state for 2 or 3 weeks or more?
Only to relocate family members who were relocating, other than short trips for the purpose of relocating those individuals. The answer is no. Insofar as I'm aware, it has remained in those 3 jurisdictions the entire time.
And again, you don't have to use specifics or proper names, but to your knowledge, has Mr. Morphew used any other names than...
Judge, before I continue with my argument, for purposes of the Victims' Rights Act, Mr. Morphew's daughters have expressed an objection or a support of the defendant's motion to reduce bond. Meanwhile, Suzanne Morphew's sister, who's also on the line here today, as well as her brother, who submitted a victim impact statement, both strongly object to any modification of the defendant's bond at this time. Judge, defense counsel is asking for a reduction of bond specifically for the reasons that the court considered. When the court had the indictment in front of them and reviewed the information that we presented with respect to our bond argument, the court considered, for example, his previous performance on bond, the previous amount and conditions of the bond, took into consideration all of those factors that defense counsel has now asked the court to consider here. But I think the most important thing that the court considered is the court had the actual indictment in front of her and read that this case is a very different case than the one that was filed in 2021. Obviously the facts of this case will be litigated in trial. Defense counsel is asking the court to consider that the evidence presented in the indictment is just slightly different than the 2021 case. Nothing could be further from the truth, Judge. In this case, the remains of Suzanne Morphew were found. The remains of Suzanne Morphew after an autopsy contained a chemical compound that Mr. Morphew had almost exclusive access to, tying him directly to the remains of his wife. The case in 2021 was arguably entirely circumstantial with no body. This case is very different. I'm hoping that the court has been able to at least review some of the transcripts of the case presentation in front of the grand jury. Obviously, the court has the indictment. The transcripts will also describe in more detail and more depth the weight of the evidence against Mr. Morphew as he sits here today. So I think I differ with defense counsel in his assessment of the case that's in front of the court. It is very different than the one in 2021. Judge, the court has also considered specifically the behavior of Mr. Morphew in 2021 with respect to his bond. I know that the defense did not have the benefit of being here during my bond argument, but specifically I asked the court asked me, was there any bond violations in 2021? What were the terms and conditions of his bond in 2021? And the court had all of that information in front of her when you determined that this was a different case and so a different bond should be set. I differ with defense counsel in his argument where defense counsel submits that a bond is too high if someone can't post it. Obviously, our jails that are full with people that can't post bond would argue in a different direction on that one. But the reality is the bond that Mr. Morphew the bond that the court has set is consistent with other bonds that are currently set against homicide defendants in the 12th Judicial District. Judge, the court specifically asked defense counsel whether or not the defendant has been using any other name. And obviously we can talk about the reasons why the defendant might have been doing that. But it's not just his middle name that he's using. He's using a last name that doesn't have any relationship or connection to his given name at birth. He's using the name Lee Moore, which is not related to anything that the defense has presented. Specifically, he's using it to conduct business in Arizona, and that's the concern that people have specifically. In addition, Judge, the court asked whether or not he's been in another state for a substantial period of time. Well, I don't have any facts to dispute what defense counsel represented. I would note that the defendant has been traveling frequently with 2 vehicles, interchanging license plates on those vehicles. In addition, we also have information and communication to suggest that the defendant has actively attempted to move around large amounts of money to different accounts. He has put properties that he owns in family members' names. He has also traveled well. He is absolutely entitled to do so. He does have the means to travel out of the country. And it's those things that give us a lot of concern about not only the fact that this is a different case, but the fact that this is a different judicial district, this is a different district attorney's office, this is an entirely different landscape. And I can imagine that the court would agree with me when I say that the defendant is under very different peril than he was in 2021. And for that reason, we have been monitoring his communications as well as his movements in terms of financial information. And it looks as though he is doing a lot of activity in that regard. Judge, he does have substantial needs, but we don't have any information that he's actually been working for the last 6 months. He's been living in Arizona, but our information, at least preliminarily, is that he has not actually had a job. He does landscaping work, but we have not been able to find any kind of incorporated business or any business name that he's operating under. So we have great concerns about what he actually has been doing in the last 6 months, where his money is going, and why he is now actively trying to shift around finances. All of those things give us great concern, Judge. I agree with defense counsel. The defendant sits here innocent until proven guilty, and I fully support that concept of our criminal justice system. But the court has to consider whether or not the defendant is a flight risk. And in these circumstances, in these very unique circumstances, a bond of $3 million cash only, consistent with other defendants in this jurisdiction, is appropriate. And the defense has not presented the court with any other material information that would support a modification of that bond at this time. And if I can just have one more, Judge. Sure.
I do have a question for you.
Sure.
Ms. Kelly. The license plate that you've brought up that was switched between vehicles, was that a license plate that was registered to Mr. Morphew or to someone else?
It is.
In his own name?
It is. It is an Indiana plate, and he's been living in Arizona for a long period of time.
Okay. But it's in the name of Barry Morphew?
That's correct.
Okay. Thank you.
As far as we can tell, I don't think we have any information that he's registered any vehicles in Arizona. He has not.
Okay. Thank you. Go ahead.
Thank you, Your Honor. So I want to be a little bit careful recognizing who our audience is, and it, of course, is the court. Your Honor, the transferring of large amounts of money, I believe, is a reference to a trailer that Mr. Morphew is residing in Arizona, and a home that Mr. and Mrs. Morphew had purchased in Indiana for roughly $200,000 and transferred it to his mother because his mother is residing there. Mr. Morphew's significant financial substantial means are something, of course, that has not evidenced itself so far in the roughly 9 terabytes of discovery that has been presided to the defense. And ultimately, the court should know that Mr. Morphew was in fact living in a trailer park in Arizona, and was driving, and his daughters were driving the same vehicles since those that had been seized and returned to them by law enforcement. There is not a substantial amount of money. I am hesitant and going to be very careful in talking about the one piece of factual evidence that the district attorney raises in addressing that. Insofar as the indictment, Your Honor, as the court knows, that is a cherry-picked piece of narrative that has been created exclusively by the district attorney, using agents by the district attorney, and by going through the grand jury, there is no opportunity for the defense to be able to publicly rebut anything that has been said. That is but mere allegations, and arguably and laughably, oftentimes wrong and incorrect. The BAM that the district attorney mentions that Mr. Morphew had access to, I want to be clear on, was prescribed to him in the state of Indiana in 2018. Mr. Morphew has not had access to BAM since 2018, and the indictment says that nobody in the immediate region, meaning the 12th Judicial District, who was not otherwise lawfully prescribed BAM, had access to BAM, leaving out the fact that Mr. Morphew himself has not had access or prescription to BAM since 2018, and ultimately, law enforcement did not find any BAM in Mr. Morphew's residence, in his garage, or in his gun safe. And so this narrative that the people put in their indictment that Mr. Morphew has ties to and access to BAM and is completely silent to the fact that that was an out-of-state prescription legally prescribed to him for a deer farm that he had not owned in years, in my opinion, is something that is not particularly relevant to this court's analysis, only insofar as rebutting the fact that the people asked the court to take into consideration a one-sided indictment with a soundbite of BAM and leaves out the context in the initial and the additional narrative. And so the bottom line is, in this case, my premise and my argument remains, which is that Ms. Bryelson and I have the burden of representing an innocent person next to us, and we believe that the facts are going to be flushed out when given the opportunity for that to be a two-sided narrative and not a one-sided narrative that we then ask the court to simply believe and take as completely and totally truthful and accurate. Ultimately here, the purpose of bond is to ensure Mr. Morphew's compliance with court order. And we are, in fact, asking the court to only consider both what has been argued today as well as the statutory factors. Thank you.
So I want to be clear that the purpose of bail at this stage of a case is to ensure Mr. Morphew's presence at the time of trial and not to punish him before he has been convicted of anything. Pre-trial, my considerations in reducing bail or modifying bond are whether or not Mr. Morphew will come to court as directed, and whether or not he is likely to commit a new offense while on bond. There are several factors I may use in making this decision. There are several factors that weigh in Mr. Morphew's favor. Mr. Morphew has the support of his family, and he alleges several friends both inside and outside of Colorado. So I want to be clear that the purpose of bail at this stage of a case is to ensure Mr. Morphew's presence at the time of trial and not to punish him before he has been convicted of anything. Pre-trial, my considerations in reducing bail or modifying bond are whether or not Mr. Morphew will come to court as directed, and whether or not he is likely to commit a new offense while on bond. There are several factors I may use in making this decision. There are several factors that weigh in Mr. Morphew's favor. Mr. Morphew has the support of his family, and he alleges several friends both inside and outside of Colorado. However, he did not identify those friends even in the sealed version of his motion, and his family lives largely outside of this state, and at least one family member lives between two states, neither of which are Colorado. That being said, I do note that, no disrespect to any of the other individuals who are statutory victims in this case, but the two, what I would consider most significant victims of this matter, are strongly supportive of Mr. Morphew's innocence and are strongly supportive of his release, and I do take that very seriously. Your opinion matters a great deal to me. Mr. Morphew has no real criminal history, except for one case that no longer exists, and neither the facts in nor the facts of that case may be used in making my decision to. If Mr. Morphew has a criminal history in any other state, no evidence of that has been presented to me. As I cannot consider that case that does not exist any longer, I also cannot find that Mr. Morphew is likely to commit a new offense while he is out on bail. Nor do I have any evidence in front of me that Mr. Morphew is likely to harass or intimidate any witness to this matter. That being said, Mr. Morphew does also have several factors that weigh against a reduction or modification of his bail and bond. Mr. Morphew has moved around a lot since 2022, which is indicative both of his mobility, i.e. there's nothing in particular requiring him to stay in a particular place, like a job or a family. It is also indicative of his ability to pick up and go whenever he wants to. Mr. Morphew has largely been self-employed, and the people have also indicated that he's continued to conduct business from jail. However, I hear what Mr. Feller is saying about what that business is to their knowledge. So jail does not seem to be an impediment to his ability to earn a living. Not that this should necessarily be an impediment to someone being released from jail, but it does not contribute to the argument that he has to be released to get back to work to do something like support a family. Very obviously, the nature of the charge alleged and the only sentence that would be available to me should he be convicted weighs strongly against a reduction or modification. I'm also taking into consideration the fact that with the discovery of Ms. Morphew's remains following dismissal of the previous case and the evidence resulting from that discovery, that puts Mr. Morphew in a very different posture than he was when his bail was set at $500,000. But the factor that weighs perhaps strongest against modification or reduction is that Mr. Morphew does not have a single tie to this community that I'm aware of. His family does not live here, and he has not identified, and in fact says he does not have a single friend or business associate in the area at all, let alone anyone willing to assist him. Furthermore, it has been argued that Mr. Morphew has the means and is quite skilled at moving around and remaining under the radar. although I have heard what the defense has said regarding Mr. Morphew remaining in contact since the dismissal of his case. But there's also evidence that he is using a different name. Given the media scrutiny around Mr. Morphew's cases, that's not wholly unreasonable. But it is a concerning indication of his ability to switch up his identity and live by an assumed name with ease. However, I also recognize and consider, in Mr. Morphew's favor, the fact that law enforcement was able to locate him relatively quickly after the indictment, and that Mr. Morphew did not deny that he was the person sought by Colorado when confronted by law enforcement. And finally, I am considering the fact that Mr. Morphew does have the means to be able to move around. It may not be the same means that were available to him a few years ago, but nonetheless, the arguments that have been made makes it clear that, unlike many people in this situation, he does not have to remain in this place or in one place at all, and it would be relatively easy for him to move around, notwithstanding his relationship to his children and other family members. And finally, Mr. Morphew does deserve to be treated similarly to those similarly situated. The prosecution's response to Mr. Morphew mentions 2 individuals, both of whom were charged with first-degree murder since the beginning of 2024. One of whom had bail set at $5 million cash only, the other of whom is set at $10 million cash or surety. Both defendants were alleged to have attempted to abscond after the events giving rise to their charges, which is very different than Mr. Morphew's situation. But similarly different, both defendants had significant and serious criminal histories, and both have significant ties to this community. I also looked at a few other homicides pending in this district, not mentioned in the people's response. One of those defendants had bail set at $75,000 cash or surety by a judge who is not from this judicial district, and another whose bail is set at $1 million in a homicide alleging that a husband killed his wife. Neither of those defendants have any significant criminal history, but they do have strong ties to this community and have raised affirmative and quasi-affirmative defenses to their charges. Therefore, in weighing each of these factors and making an assessment of Mr. Morphew's specific situation, I declined to reduce his bail, but I am going to modify his bond. I'm going to modify his bond to a cash surety or property bond. In this district, we often set bond at a higher surety or property option with a lesser cash-only option, but I won't be doing that in this case. The reason why is because if Mr. Morphew posts bond through a surety and then absconds, he not only has $300,000 on the line, but there's also a bail bonds person who would be tracking him down. And if he chose to post a cash-only option, then he would have $3 million on the line. If Mr. Morphew posts bond, the added conditions are that Mr. Morphew may not leave the state of Colorado for any reason. Mr. Morphew will have a GPS monitor placed on him before he is released, and he may not leave his home for any reason except for medical emergencies, to attend medical appointments, to meet with his attorneys, or to attend court. The GPS monitor company shall submit a report to the court at least monthly and shall report any violation, including tampering with the monitor or failing to keep it charged immediately. Mr. Morphew will surrender any passports he has. He will also use only the name Barry Morphew in any personal, legal, and business dealings, and he may not petition to change his name legally during the pendency of this case. He may only drive vehicles that are properly registered to him and that comply with the Colorado Department of Revenue's rules. And finally, Mr. Morphew shall comply with the mandatory protection order that I'll be issuing here momentarily and will advise Mr. Morphew about in a few minutes. Ms. Kelly, any questions about my order?
No, thank you, Judge.
Mr. Beller, Ms. Pielson?
Yeah, thank you.
Okay. All right, before we turn to the status of the case, in just a moment. Mr. Morphew, I have to issue a mandatory protection order. This has nothing to do specifically with you or any particular factor in your case. It is issued in any case, criminal case in the state filed under Title 18. So what that protection order prevents you from doing is harassing, molesting, intimidating, or bothering any witness to or victim of this matter. Okay, so no telling witnesses not to testify, no talking to them about their testimony, no harassing anyone, etc. Very often there is an order that you not contact any victim of the case. I understand the most significant victims of this case are your daughters, and so I am not going to issue that, because that is not something that they desire to have. I don't know that anyone has discussed anything with Ms. Morphew's other family members, but it's probably in your best interest to not contact them. You may not possess or control any firearm, ammunition, or any dangerous weapon. I understand that your business may include large knives, things of that nature. Make sure if you are engaged in that business, you talk to your attorneys about whether there is a concern that may violate the protection order, okay? Specifically, very large knives are a problem for you with the protection order. And finally, you may not consume any alcohol or any controlled substances without a prescription, okay? I will issue that protection order later on today. I will send that to your attorneys. They will get a copy to you, okay? All right. If you have any questions, I'll give you a moment to ask your attorneys.